In this section, I will explain how the Queensland government's new law overrides the state's Human Rights Act and makes breach of bail an offence for children, which is incompatible with international standards and human rights principles. Breach of bail is when a person who is released from custody on certain conditions fails to comply with those conditions. For example, if a person is required to report to a police station every day but does not do so, they have breached their bail. Under the current law in Queensland, breach of bail is not an offence for children. This means that if a child breaches their bail, they cannot be charged with a criminal offense or sent back to detention for that reason alone. Instead, the court can consider the breach when deciding whether to grant or revoke bail for the child. However, the Queensland government has introduced a new legislation that will change this. The new legislation will make breach of bail an offense for children, punishable by up to 1 year in detention. The government says this is necessary to deter repeat offenders and protect the community from serious youth crime. But this new law will also override the state's Human Rights Act, which was enacted in 2019 to protect and promote the rights of all people in Queensland. The Human Rights Act recognizes that children have special rights and needs, and that detention should be a last resort for them. It also requires the government and public authorities to act compatibly with human rights, and to justify any limitations on human rights. The new legislation admits that making breach of bail an offense for children is incompatible with several human rights, such as the right to liberty and security of person, the right to a fair trial, the right to be treated with humanity and respect, and the right to protection of the best interests of the child. It also admits that there are less restrictive ways to achieve the government's objective of reducing youth crime. But the new legislation claims that overriding the Human Rights Act is justified because it is reasonable and demonstrably justified in a free and democratic society. It also claims that it strikes an appropriate balance between protecting human rights and ensuring community safety. However, many human rights advocates and experts disagree with this claim. They argue that making breach of bail an offense for children is ineffective, unnecessary, harmful, and discriminatory. They say that it will not reduce youth crime, but rather increase the number of children in detention, which is already overcrowded and under-resourced. They say that it will expose children to more trauma, violence, and abuse in detention, which will worsen their mental health and well-being and increase their chances of reoffending. They say that it will disproportionately affect Aboriginal and Torres Strait Islander children, who are already overrepresented in the youth justice system. And they say that it will violate Australia's obligations under international law, such as the Convention on the Rights of the Child, which prohibits arbitrary detention of children and requires alternatives to detention. Therefore, making breach of bail an offense for children is not only a breach of human rights, but also a bad policy that will harm children and society.